How are we doing, pre-lit family? Stephen Palmieri coming to you here today. And a few days ago, we did a video talking about the FCRA's reasonable procedures requirement that it imposes upon the credit bureaus. And I had a lot of people question and reach out to me wanting a little more clarification on that, and specifically how the FCRA eliminates some of the consumer's ability to pursue negligence and other common law type claims. So what I want to do is do a video and just kind of back up for a little bit historically and just help us understand kind of how we got to where we are in America with our current court and legal system. Again, I'm not an attorney. I'm just sharing with you the information that I know. But so here we go. So prior to FCRA, there was no FCRA. So if you felt as though you were done wrong, as they say, what you would do is the most common remedies is you would have to get an attorney and try to sue the credit bureaus for something such as negligence, defamation, invasion of privacy. Those would be the most three common types of claims that you could basically accuse a credit bureau of having done to you, right? You know, hey, if they said something about you that was not proper, well, were they negligent? But what is negligence? That's what we're going to talk about. Did they defame you? But I mean, like, what is defamation? And did they invade your privacy, right? I mean, because if they were like saying these private, things about you and your mode of living and your character, well, these things should be private, maybe. That was your argument. So prior to FCRA, those were the general remedies at hand. And where do those remedies come from? Well, we have to kind of look back to how the United States legal system has evolved. So it has evolved from England, from Britain, over hundreds and hundreds and really almost 1,000 years of what are called precedents, right? And at the very heart of it, what you do is if you had a grievance, hundreds of years ago, in Britain, you would go to the king and you would see the king's men, and he would have somebody who used their conscience to render a judgment, right? And my judgment, my best estimation, based on what my conscience tells me, here's a decision that I'm going to make, right? If you were living 600 years ago and your neighbor stole your chicken or whatever off of your farm and you had a grievance, there was not like a law that said, here's the problem and the remedy if the neighbor steals the chicken off of my farm. So you would go to the judge or whatever they would be called, and you would have your argument, and there's just these general concepts, like in that case would be something like theft, right? There's these general concepts, and then the person hearing it, which would be like the judge, would render a judgment based on his conscience, what he thought was right or wrong, right? So without any sort of like a clear cut, in today's age, statutory law that our Congress makes, you have a background of hundreds and hundreds and hundreds of years of disputes being resolved without actual lawmaker laws on the books. And so all these precedents have evolved from judgments, from judges using their conscience to make a best decision, right? And so the way that our system works, the common law system, is all prior precedents build on future cases if the fact pattern is the same. Okay, so that's kind of how the common law type thing has come together. So, prior to FCRA, you went and the credit bureau said something about you. That is kind of where negligence, defamation, invasion of privacy come from. It just comes from our common law, which comes from just hundreds and hundreds of years of these types of issues being decided. Okay, so that's where those principles come from, right? So now we have Congress, which can make statutory law, and they have the authority to do that under our Constitution, assuming it's a constitutional law. We won't get into that in this video, right? You guys get that. But anyway, our Congress does have the ability to create statutory law, which is not two people going to a judge to resolve a grievance. This is a bunch of lawmakers creating law because of the powers they have under the Constitution. Okay, so when the FCRA was created, then Congress said, okay, you know what? We're going to force the credit bureaus to have a dispute process. But because credit reporting is important, we're going to go ahead and keep the consumers from being able to sue them for negligence, defamation, and invasion of privacy in most situations. So it's kind of a give-take. So Congress then actually removed some of those common law type remedies because they made it into the FCRA, into the statutory law that says you don't have these remedies. But then they created additional remedies under the FCRA. So let's take a look at that. So now that we've kind of gotten to high level, okay, how in the world, like, did we get to where, like, what is negligence, right? How do we get to where we are? Okay, so let's dive back into this and take another look. So let's do a share screen here. Okay, give me a minute. And let me open this up. So we're going to take a look at, this thing opens up here. Let's see. There we go. All right. Okay, so we're going to take a look at the U.S. Code, the Fair Credit Reporting Act. Okay, we had talked about this on our other video, but we're going to kind of, just for the sake of clarification, go over it a little bit more and a little differently. So 1681H is a section of the FCRA, specifically HE, where it has a limitation of liability. Okay, so this is a law passed by Congress. And so what it says is that except for provided under sections 1681N and O, which are sections of the FCRA that Congress created to give the consumer remedies if the bureaus violate the FCRA. So basically, except for the remedy sections that Congress is creating in this statute, statutory law, no consumer may bring any action or proceeding in the nature of, okay, so related to defamation, invasion of privacy, or negligence. So basically what Congress is saying is, hey, you know what? You're no longer going to be able to go to a credit bureau or a data furnisher or a user of information, which would be like a dealership or a mortgage company, and accuse them of any one of these three type things. Instead, you have to go through the process that FCRA creates, which is a process that now puts the burden on the consumer to give them a dispute, but then it puts the burden on the bureaus to have reasonable procedures to properly investigate. So there's really a give-take there. So unless this information is furnished, is false information furnished with malice or willful intent to injure. So basically Congress is saying, okay, if you can argue that the credit reporting is false and it was furnished maliciously, then you can go ahead and pursue defamation, invasion of privacy, and negligence. But apart from this, what Congress really did was said basically, hey, we're not really so much concerned about you enforcing the accuracy of the reporting per se, as opposed to enforcing whether the credit bureaus have reasonable procedures when you put them on notice of the errors. That's essentially kind of how this thing was designed. So this is where that is. This is what that means. So they're forcing the consumer to use these remedies, but it's not so bad because the consumers now have the dispute process, which requires reasonable procedures. And all of us who have ever disputed credit, we know their procedures are highly unreasonable, right? I mean, they really just don't fix things very good. So if we actually understand how to send good disputes to the bureaus, it's really not too hard to be able to argue that their procedures failed, right? So let's take a look at 1681N and O. 1681N provides civil liability for willful noncompliance. And so, again, right here in this section is called noncompliance, right? Because again, the statute really provides that the bureaus need to have reasonable procedures. So, what it's basically saying, we don't need to read this whole thing, but essentially, if the consumer can argue that the credit bureaus were not compliant and were willful, okay, well, here's a way where they can get some remedies and basically enforce the consumer's protection. And 1681O is very similar, except this is for negligent noncompliance, okay? So the takeaway here for you guys is to understand that although accuracy is important, accuracy is very important, But what's really important is working the mechanism that Congress has created. Okay, and what Congress did was they created a dispute process through which the consumer can navigate, and it puts the burden first on the consumer to have a reasonable dispute. I mean, you can't just send some garbage to the credit bureaus, okay? But if you have a reasonable dispute, articulate it, write it down, put the bureaus on notice, send it to them, and then the burden shifts to them to have reasonable procedures to properly reinvestigate. And that also goes to the furnishers, because the bureaus will forward that information to the furnishers. They're supposed to work together in concert to resolve the issues. So if you put them on notice of things that are clearly wrong, especially if you give them a copy of their own credit report, again, the burden is on you to put a well-crafted dispute together. The entire thing is based on a standard of reasonableness. That's really the takeaway here. So you're not going to really sit around and say, oh, I'm upset because, you're not going to take your case to an attorney and say, these people are reporting inaccurate information, and I don't like that. Because we just reviewed it. Inaccurate information is really no longer actionable unless it's false information furnished with malice or willful intent to injure. Inaccurate information is very important, but that's how we get to opening up the reasonable procedure liability, if that makes sense. You put them on notice of what's wrong. If it's still wrong after you put them on notice, you're going to have to argue that the procedures to reinvestigate are what failed. And of course, it failed because you gave them enough information to correct the information, and they didn't fix it. So the takeaway here, guys, just kind of focus on the accuracy, absolutely, when you put the dispute together, but you have to understand that the remedies are not really saying, oh, well, it's not accurate. The remedies are, oh, well, it's not accurate, and we put you on notice of why, and you failed to correct it. So because your procedures were not reasonable and you failed to correct it, that is where 1681N and O. Let's see. Timothy Williams says, show the material is misleading. So, that's a good point. What is accuracy? Misleading information can be and has been argued to be inaccurate. But the idea here is we could talk a lot of different ways about what is accurate, but on this quick video, we want to talk about really getting our head wrapped around the right argument, okay? And the argument is, and so in this case, Tim, if you're saying the material is misleading, can you put together a good dispute and send that dispute to the credit bureaus and demonstrate to them why the information is misleading? And is the result after the reinvestigation still misleading, right? Because in that case, then you're going to have to make the argument that their procedures were unreasonable, because for whatever reason, they're still reporting misleading information, which would be inaccurate. So there you guys go. Appreciate you all for watching this. Hopefully this helps you understand how we got to where we are, and also hopefully it helps you understand why, when you talk to the attorneys and you're trying to hand, either as a consumer your file or as a credit repair organization your client's file to the attorneys, and they're like, oh man, I love your passion, but I just don't see anything here. Hopefully now you can understand, because a lot of times we're approaching it from the wrong perspective. We want to focus on inaccuracy, but we really need to focus on their procedures. If you can focus on their procedures, then it is on like Donkey Kong, my friend. So that being said, if you like what you see here, we do have our training course for credit repair organizations. Go to creditrepairtrainingcourse.com. Check it out there. Feel free to shoot me some likes, some loves. Follow me on YouTube, Stephen A. Palmieri, and I will see all of you on the next video. You guys take care.